Good morning and welcome to the 6th Annual SABWiL Human Rights Court. My name is Promise Hlongwa. I am the Projects and Events Coordinator and I will be the registrar for today's proceedings. I would like to please call our SABWiL Alumni Secretary General, Ms. Lerato Koza, to do our welcoming.
Thank you, Promise. I hope that everyone can hear me or they can see me. Thank you so much. Immediately when I saw the scenario today, I immediately thought of a quote by Edward Snowden, who once said that, and I quote, "Arguing that you do not care about the right to privacy because you have nothing to hide is no different than saying you do not care about the right to free speech because you have nothing to say." And this quote emphasizes on the significance of the right to privacy for all human beings. This is very important as the right is entrenched in terms of our constitution in the Republic of South Africa. However, through the advancement of technology and the fourth industrial revolution, it's rather difficult and or impossible to maintain private, or rather to maintain the right to privacy. The possibility of billions of mobile devices with unprecedented processing power and access to knowledge, the rapid growth of the use of social media, the internet, the devices, our cell phones, our laptops, our tablets, the devices in our cars. These tools are used to store our personal information and we use them on a daily basis. So if such information is leaked, such as our case today, the consequences can be dire. Ladies and gentlemen, good morning, and I welcome you to the SABWiL Annual Human Rights Court. Without wasting any further time, I would like to acknowledge the presence of Chief Justice Deputy Chief Justice Bowman. I would like to acknowledge our third justice for today, which is Justice Advocate Nyawini. I would like to acknowledge the presence of the SABWiL CEO and founder, Advocate Tyree. I would like to acknowledge the presence of our President Cleopatra Mahao. I would like to acknowledge the MEC as well as our participants. And you, ladies and gentlemen, thank you so much for joining us today. Thank you.
All right, thank you, SG, for that warm welcome. I would now like to please state that our rules of engagement are as follows. Can we please ensure that our mics are turned off as well as our videos? And if it does happen that you are speaking, can you please ensure that your phone is also on silence? That would be highly appreciated. Okay, so I would like to please call on our alumni president, our lovely Miss Cleopatra Mahao, to please do her presidential address. Thank you.
Thank you very much, Promise, and good morning to you. And good morning, ladies and gentlemen. Thank you so much for joining us. I would like to begin by greeting our CEO and founder, Advocate Aisha Tyree, the members of the board, members of the executive committee, members of stakeholders, esteemed and honorable justices. We appreciate you being here. SABWiL luminaries, SABWiL alumni, and all our guests that are present here today. And I'll just like to say all protocols observed. SABWiL is an international consciousness movement that celebrates South Africa, Blacks, women, and law. We are founded upon dignity, equality, and freedom, infused with the philosophies of Ubuntu and the spirit of Zenzele. The spirit of Ubuntu and Zenzele is the primary reason why the SABWiL Human Rights Court exists, because at SABWiL, we feel that it is better to teach people how to fish instead of giving them fish. And these proceedings provides lost students with the opportunity to sharpen their critical thinking skills, drafting skills, presenting oral arguments, as well as building their confidence by getting them acquainted with the court environment and court proceedings. And I am pretty sure that a whole lot of law students will agree with this one, especially now during the times of COVID, where a whole lot of things are happening online. We find ourselves having to have court proceedings online as well. So this is a great opportunity to learn how this works in the real world as well. So this doesn't just it is something that all of us can learn from, because I'm pretty sure that most of us are either aspiring legal practitioners or already in practice. And mooting as an exercise also helps law students with developing fluency and clear enunciation, and also gives them experience in the art of persuasion and of putting a case succinctly and intelligibly. Congratulations to the participants for making it this far. We are looking forward to being dazzled by your brilliance today. I have no doubt that you will remember this experience for a very long time to come. And please don't forget to enjoy the proceedings today. I'm pretty sure that everyone is nervous. It is understandable, but also enjoy this experience. I would like to extend, excuse me, I would like to extend a very big thank you to our esteemed and honorable justices for availing themselves today. We know how busy your schedules are, and we are truly grateful to you. Thank you, thank you, thank you, thank you very much. Promise I'm going to leave it there. I'm going to keep it short. I've got a bit of a scratchy throat today, but thank you so much for allowing me to just address. Back to you.
All right, thank you so much, Madam President. I would now like to please call our SABWiL Alumni Treasury General to explain our case scenario.
Very good morning to everyone. We would like to sincerely apologize about this. Our Treasurer General, who's supposed to give us the case scenario, is having problems with logging in, and yeah. So he's really been trying to log in, but he's failing to do so. So without wasting much time, since we've already wasted so much time, I will just quickly go through the case scenario. So this is a matter between Haibo Mama and Haibo Dada. The applicant in this matter is Mama Haibo, a 42-year-old sales assistant. She's been married out of community of property to the respondent Dada Haibo since 2011. They have 2 children, Rain and Summer, who are 8 and 5 years old, respectively. Mama Haibo has instituted divorce proceedings against Dada Haibo. In her particulars of claim, she avers that the reason for the irretrievable breakdown of the relationship was, amongst other things, that Dada Haibo was prone to fits of rage and violence, that he drank excessive amounts of alcohol, and that he was physically abusive, and on one occasion made a verbal threat on Mama Haibo's life. Dada Haibo filed a plea in response to Mama Haibo's particulars of claim, in which he denied each one of the allegations against him. He pleaded that even though he conceded that he would occasionally lose his temper and shout, he would not become physically aggressive against either Mama Haibo or the children. He also conceded that he had on one occasion threatened Mama Haibo while he was upset, but this should not have been construed as a threat on her life. It was merely an unfortunate statement uttered in a moment of anger and was not intended as any genuine threat. In a counterclaim, Data Haibo admitted that the relationship had irretrievably broken down, but averred that the grounds for breakdown were that Mama Haibo was emotionally and verbally abusive and would scream at Data Haibo and at the children, and would drink excessively and neglected the children. Shortly after saving the summons against Data Haibo, Mama Haibo left the matrimonial home together with the children. And Mama Haibo sent a text message to the father telling him that she had left with the children. She indicated in the messages that she would not disclose where she would stay, and in the interim, she warned Data Haibo not to try to find her or the children. She ignored the messages that the father sent to her in response. Data Haibo initially brought urgent proceedings to the children's court to ensure the return of the children and accused Mama Haibo of kidnapping the children. However, he subsequently withdrew his urgent application. In correspondence, his attorneys notified Mama Haibo's attorneys of the following. The Toyota Fortuner is owned by Data Haibo, but in the best interest of the children, he will not bring a claim vindicating the vehicle. The Fortuner is fitted with a GPS tracking device and a dash cam, which were installed by the manufacturer. These devices are connected to an application on Data Haibo's phone and transmits data to his device. Data Haibo withdrew his urgent court application because he was unable to discern, using the GPS tracking device, that Mama Haibo was staying with her mother. The urgent application had become unnecessary. The dashcam also had a built-in microphone, and some of the conversations in the vehicle had been recorded. This corroborated Data Haibo's claim that Mama Haibo was verbally abusive towards the children, and transcripts of these recordings would be used as evidence in the divorce proceedings. Data Haibo's attorneys included a copy of the recordings and the transcriptions, which included date and timestamps. These recordings demonstrated that over the course of at least a year and after she had left, these recordings demonstrated that over the course of at least a year and after she left the matrimonial home, Mama Haibo would frequently raise her voice at the children. Mama Haibo would frequently raise her voice at the children, swear at them, and threaten them. Amongst other things, Mama Haibo shouted at the children that if they returned home to Daddy, we will all die. In a couple of recordings, one can clearly hear Mama Haibo smacking one or both children. Mama Haibo now seeks an order for the removal or disconnection of the GPS tracker and the dashcam, and an order declaring that the dashcam recordings and the transcriptions inadmissible as evidence in the divorce proceedings or in any other litigation against her. She argues that this constitutes a serious infringement of her right to privacy. They also deprive her of the ability to use the vehicle to the children's and her own detriment, referring to Data Haibo's history of aggression and violence. Mama Haibo indicated that she feared for her children and her own safety, noting that Data Haibo was able to track her movements and whereabouts in real time on her cell phone, posing a serious threat at any time. She also argued that the recordings of the dashcam constituted an infringement of her privacy, as well as an infringement under Section 2 of the Regulation of Interception of Communications and Provision of Communication-Related Information Act 70 of 2002, and that Data Haibo was not entitled to use this information in court proceedings. Data Haibo opposes these proceedings. He emphasizes that the GPS tracker and the dashcam. Data Haibo denies that the devices constitute an infringement of Mama Haibo's privacy. He submits that the GPS tracking of vehicles is commonplace, with many insurance companies offering lower rates on vehicles that have tracking devices installed in the vehicle. The dashcam is also a commonplace feature designed to collect information in the event of an accident. If someone caused an accident because of reckless driving, for example, it could hardly be argued by that driver that the evidence is inadmissible or constitutes an infringement of their privacy. He also points out that regardless of whether the collection of the vehicle data constitutes an infringement of Mama Haibo's privacy or not, the recordings do not in fact constitute evidence of Mama Haibo's assault of the children, a criminal offense. He argues that it is in the best interest of the children that the evidence be admitted and that the dash cam can be retained in the interest of their safety and under the principles of accountability. Insofar as Mama Haibo does not abuse the children in any way, she has nothing to fear in respect of the recordings. Considering the alleged infringement of privacy, Tata Haibo makes the following with prejudice offer. He would uninstall the app on his phone and would not personally track either the movement or the recordings of the vehicle. Instead, Tata Haibo's attorney or an independent third party would be given access to the app. In her replying affidavit, Mama Haibo rejects this offer as unsatisfactory, indicating that the mere surveillance of the vehicle constitutes an infringement of her right to privacy. Regardless of whether Tata Haibo had the necessary intention or not to install the device on the vehicle, the point is that upon discovering that he had access to this information, he intentionally downloaded the recordings and the location of the vehicle. She persists in her claim. Access to Justice South Africa has been admitted as an amicus curiae as an organization that focuses on restorative justice and has a special interest in preventing domestic violence. It deposes the following. In today's world, a significant portion of our information, including personal information, is recorded without any awareness or notice. For example, some providers or virtual maps keep a historical record of a person's location to provide a better service to the customer. Photographs taken on a cell phone also contain location data as part of their metadata. Although seemingly innocuous, this information can be gathered and used maliciously. A person responsible for domestic violence may use this information to track down a victim. This constitutes not only a breach of the right to privacy, but also the right to freedom and security of the persons enshrined under Section 12 of the Constitution. On the other hand, this information can be used for the beneficial purposes. It may be used, for example, to track victims of unlawful abduction or kidnapping. One of the central features of the problem is that this information is often recorded without the subject of the information being aware. This is indeed the case in this matter, where neither Mama nor Tata Haibo were initially aware that the vehicle recorded all this information. The amicus submits that the collection and use of this information is an infringement of privacy, but this cannot be the end of the matter because evidence of abuse against children should not be stifled in the name of privacy. Rather, the court should have the discretion as to whether to use the information or not. This should follow the ordinary principles set out in legislation and considering the rights in the Bill of Rights. Information should not be collected without a judicially obtained warrant or unless a police officer has reasonable grounds to suspect that an offense is being committed and reasonably believes that a warrant would be granted in the circumstances but cannot be obtained. No person may be subjected to the surveillance in the ordinary course without any reason. Having read through the papers, the court has asked for submissions on the following points. Does the mere collection of information by the tracking device and or dashcam constitute an infringement of the right to privacy as enshrined in Section 14 of the Bill of Rights? Does Tata Haibo's access and use of the information gathered by the above device constitute an infringement of the right to privacy of Mama Haibo and the children? Does the mere collection through the installation process and or the access and usage by Tata Haibo constitute justifiable limitations to the privacy rights of Mama Haibo and the children in terms of Section 36 of our Constitution? Must these collection devices be disconnected or removed, or will bearing Tata Haibo's access and usage suffice to ensure lawfulness prevails if privacy and dignity rights are indeed violated? If the devices are not disconnected or removed, should it be open to a third party or an attorney to collect the information recorded by these devices for use in an emergency or in the event of the commission of a crime? Should the information that has been gathered by Tata Haibo be admissible as evidence against Lara either in civil or criminal proceedings. Does the fact that Mama Haibo put forward no cogent evidence to demonstrate that Tata Haibo is violent towards her or the children change any circumstances above? So this was the court scenario, and I will quickly hand over again to our court registrar, Promise Longo. Thank you.
Thank you. Okay, so now we will log out of this link and log on to the second session, the link of which is provided in the program, and this will commence at 9:57. Thank you.